Hello, my name's Osha. I like discussing American presidents. Today I'm going to be continuing my discussion on the Fourth Amendment. The Fourth Amendment is part of the Bill of Rights, which was authored by our fourth president, James Madison. Now, I want us to notice the through line in our founding documents, right? From the Declaration of Independence, authored by Thomas Jefferson, it states certain grievances, and we notice there was a resolution after our independence in the Constitution. Many of those grievances now became part of the Bill of Rights as protections, and one of them is the Fourth Amendment. Now, today I'm going to be discussing a pivotal, a landmark case called Weeks versus um, United States, which is of 1914. It was decided on the 24th of February 1914 by the Supreme Court. The presiding judge then was Edward White. Um, Now, before I go further, what I'm going to do is I'm going to just recite the Fourth Amendment to remind us of what the Fourth Amendment is and what it was protecting. So I'm reciting from memory. I tried to memorize some of these uh, important amendments. It's very good for me, and I think it's good for the rest of us Americans. Just what our uh, to remember what our constitutional rights are. So the Fourth Amendment says the the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's very important. These things are going to come up in this particular case, Weeks versus United States. I'm going to repeat the Fourth Amendment again, just to make it smoother. And that is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, right? Against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the things or person and the persons or things to be seized. So that's very important. Going to come up in this particular case I'm describing. So I want us to notice, like I said, the connection, right? The interconnectedness of um, the grievances and then the rights that were now enshrined in our Bill of Rights. And in this instance, the Fourth Amendment. So in the Declaration of Independence, um, the Thomas Jefferson is citing is accusing the King of England, the King of Great Britain, who was our sovereign of even the colonies at the time. He was giving as a justification for us, fighting for our independence, that the king prevented the proper administration of justice. Right, that's cited as one of amongst the grievances. He was preventing the proper administration of justice. He accused the king of preventing trials, preventing us from having trials by a jury, right? That goes into the Bill of Rights, although that goes into the Sixth Amendment as a protection in the Bill of Rights. Then he talks about the quartering of soldiers, that soldiers were being quartered, and there was a quartering of soldiers, and they committed all these abuses, sometimes murdering, our inhabitants, and but they were protected right? They were protected by mock trials, right? So they're basically saying that the judges were not impartial, right? They were partial judges. They were biased judges, biased towards the king, the crown, the government, against the people. And in fact, they did say it that uh, he appointed judges. He made them dependent on his will alone, on the will of the king. So they were not independent. So they're saying that, well, what Thomas Jefferson is describing here is a corrupt judicial system that's not impartial, that's biased, that's not fair, right? So you see, the Fourth Amendment is dealing with fairness, right? The fairness, protecting the rights of individuals. When they mention quartering of soldiers, that goes into the Third Amendment, and quartering of soldiers, that has come to be understood and interpreted as protecting the privacy of Americans, our privacy rights, So, and you see, that's what Weeks versus the United States starts to do. It starts to establish the foundation of what's called exclusionary rule. It established the exclusionary rule. So that means if if items are seized from our homes without a warrant, then those items cannot be used by the government as evidence. They have to be excluded, and that's the exclusionary rule. And you see later on, it evolves over time, and we now have what's called the CATS two-part CATS test. I just did a video discussing this, and that was in 1967 in CATS versus the United States, which established that and it has to be a reasonable expectation of privacy. That's a protection. That we're protected. The Fourth Amendment protects us for protects our reasonable expectation of privacy, right? And so you see, Weeks is sort of a precursor of that two-part CATS rule that doesn't come until is in 1967. But in any event, the Weeks versus United States was decided in 1914, February 24, 1914. The presiding judge was Edward White, and amongst the justices were Oliver Wendell Holmes, who features, he makes significant remark in a subsequent case, Silverthorne Lumber Company versus United States. I've discussed that, in which he talks about derivative evidence, which is actually the fruit of the poisonous tree, when he says that um, it is a lesser evil for um, for some criminals to escape than that the government play an ignoble part. That's in uh, police misconduct, government misconduct, in violating the constitutional rights of Americans or citizens or people to be, uh, you know, free from unreasonable searches and seizures without a warrant, right? So now note that many of these Bill of Rights, especially things that have to do with due process, which the Fourth Amendment is connected with. We normally think of due process as the Fifth Amendment, but the Fourth Amendment is also connected with due process, right? In being fair, right? Fair legal proceedings, right? Towards when you go to court. So these are applicable not just to United States citizens. It doesn't talk about the status of people in America, but people within the American jurisdiction. That's people who are in America. So uh, undocumented immigrants, undocumented people are also protected by these due process Bill of Rights um, amendments, right? So now let me just quickly give the backstory of the Weeks case. So a guy called Freeman Weeks on December 21st, 1911, was arrested by police that's local police. He was arrested by police um, in Kansas City, Missouri. And after they arrested him, upon arrest, they went to search his home without a warrant. They got his key from a neighbor, but they didn't have a warrant, and they went into his home, and there was what's called a chiffonier, where there was a drawer that's like a cabinet, and they just searched his home and they found papers and documents. They found personal papers, his documents, his letters, and they handed these over to federal marshals, right? And federal marshals subsequently used the papers, the documents that were delivered from local police. It was local police who went to raid his home, right? They went, searched his home without a warrant, got the documents, and then handed them over to federal marshal, U.S. marshals, right? Federal agents, U.S. marshals. So those federal marshals now used those documents that were obtained to secure the conviction of Weeks for transporting lottery tickets through the mail. That was a federal crime. It was a criminal offense. It was also linked to mail fraud. So it was a crime to transport lottery tickets through the mail. So they got his conviction. So, however, what Freeman Weeks did, Mr. Weeks did, was he decided to file an appeal. So he became what's called a plaintiff in error, right? And it went all the way to the Supreme Court. And the plaintiff in error, let me just, I have to remember to just define some of these terms because, I'm a lawyer. Other people are not lawyers, and my goal is to help people sort of understand the law. Um, by the way, let me just quickly point this out. I always give this disclaimer that I'm a lawyer, I'm not an attorney. Remember, all attorneys are lawyers, but not all lawyers are attorneys. Attorneys are people who are licensed, they've taken the bar exam, they've passed it, and they've been sworn in as lawyers, officers of a court of a particular state to practice law, so they can deal directly with clients outside. They can represent clients. That's what an attorney is, one who represents clients. But let me just quickly mention this. So while I have a doctor of law, it's called Juris Doctor. In Latin, it actually translates, it means teacher of the law or teacher of legal knowledge, right? That's what Juris Doctor actually means. It's a Latin term, doctor of law. It means Juris Doctor. It means teacher of the law. So I'm a lawyer, not an attorney. So in any event, so he becomes plaintiff in error. That's Fremont Weeks. He becomes plaintiff in error and files this appeal, and it goes all the way to the U.S. Supreme Court. So plaintiff in error is it could be a defendant. That's somebody who's saying they're filing an appeal. They're an appellant, right, to a higher court against the decision of a lower court, a trial court. They're saying that they made a mistake in the application of the law, right? That there was a mistake in the application of the law. And in this case, what Freeman was saying was that because there was no warrant by the police, that they violated his Fourth Amendment rights, right? The Fourth Amendment, remember, I read it. The reason I recited it earlier was that to remind us that it prevents illegal searches and seizures without a warrant, right? Illegal search is the same thing as unreasonable searches and seizures, right? So if it's reasonable, if there's a warrant, if there's probable cause. I'll do a video later on discussing what probable cause is, because that's another complexity of its own as well. But let me just recite that. Let me recite the Fourth Amendment again to remind us, so we can apply it to Fremont Wilkes' situation. That's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, right, supported by oath or affirmation, and particularly describing the place to be searched, right, and the persons or things to be seized. None of that took place, right? So we notice papers, unreasonable searches and seizures that happened. So the police just went to his home, seized his papers, went into his cabinet, right, his drawers in a chiffonier, and grabbed his documents, his personal papers, right, And you see in the Fourth Amendment, it's actually talking about papers. It's talking about houses. So they went into his private house, his private residence, went it through his papers, his effects, right? And they seized these things and they handed them over to federal U.S. federal marshals, right? And they secured his conviction. So Weeks was saying that this was illegal. It violated his Fourth Amendment rights because there was no warrant. It was a warrantless search and seizure. So the justices they agreed with him, and they reversed the decision of the lower court, and so that became part of the foundation. It became a landmark case, a foundation, an established rule. That's the exclusionary rule. That evidence that's illegally, obtained without a warrant by the police or law enforcement will be excluded, cannot be used for in a trial. And the justices, they said that they affirmed that the papers that were illegally obtained without a warrant from the house of Fremont Weeks could not be used in his federal trial. Later on, this was first of all applied to the federal cases, and later on in 1961, in a case called Mapp versus Ohio, the exclusionary rule was applied to the states as well. So that's what the exclusionary rule is. Again, it's a prophylactic rule. A prophylactic rule is a judicially crafted rule to protect a constitutional right. In this case, the constitutional right is the Fourth Amendment, freedom from illegal search and seizure without a warrant. And so when a uh, the objective of a prophylactic rule is that when it is violated by law enforcement, by police, by the government, then there should be consequences. There should be remedies. So the consequence is that the judges, the court excludes that illegally obtained papers from the court proceedings. They can't be used as evidence against the defendants. Remember, the burden of proof is on the state in a criminal case. It's up to the government, right, to prove beyond a reasonable doubt to a jury that the defendant is guilty. And what they use to convince the jury is, or the judge, or the fact finder, is the evidence, right? The evidence that they obtain. So the exclusionary rule is saying that if the evidence was obtained without a warrant from the house of the defendant, then that evidence has to be excluded. It can't be used, and that's the Weeks versus United States case, and it was decided in 1914. So I think I've pretty much touched on the very important aspects. And again, I want us to notice the through line, how it starts from the Declaration of Independence, where Thomas Jefferson, our founding fathers, the framers, are complaining against the unfairness in the judicial system, right? And you see, it would be unfair to use evidence that was illegally obtained by the government, to use it to convict a defendant, and so in violation of their constitutional rights. And you see, those complaints were now transferred. They were now applied, they were not applied in the Bill of Rights by James Madison. And that's the Fourth Amendment in this case, right? The Fourth Amendment protecting the people from the government just invading our homes and seizing things without a warrant from a neutral judge, right? And, supported by probable cause. And so that's Weeks versus United States, establishing the exclusionary rule. I'm going to do subsequent videos later on. I think I've pretty much explained what the exclusionary rule is and its origin. My name is Olurotimi Osha. I like talking about American presidents. I will keep you posted. Thank you.